a belated Happy Thanksgiving and an early Merry Christmas, hopefully. So there's not a whole lot in terms of status to provide. I'm going to give you a little bit of a rundown, and then we can ask questions, as we typically do. The reason why there's not a whole lot going on is because we are engaged in the litigation, which has its own time frames attached to it. We amended the complaint in federal court, which gave the defendants the ability to have more time because now they had to answer the new amended complaint. So that process is proceeding forward. We've had a couple of conferences with the judge. The judge is very much aware of the need to move things quickly, but at the same time, he wants to make sure that parties have the time that they need to do what they have to do to defend their various positions. So we have, just to update you, which many of you know, we do have the settlement that was approved by Judge Stern with the old St. Joe's, old Roger Williams, and Charter Care Community Board. And for those of you who don't know, which there probably isn't anybody in this room that doesn't know, but that settlement is approximately once, if and when it's finally approved, because we have to get it approved by the federal court. But if and when it is finally approved, it will result in an immediate cash infusion of approximately $12 million into the plan. It also gives me certain rights and interests that I can pursue, and that those could also potentially result in money into the plan. One of the larger ones is the interest in the joint venture with Prospect, in which, depending on how you calculate it, it's a little complicated, but let's just say that the interest of the plan or the interest that I'd be getting from Old St. Joe's, which would come into the plan, is anywhere between 15 and 27% of the Prospect Hospital. That's a right that I'd be getting through that settlement. So while I cannot fully quantify the rights and interests that I'm getting, it would be safe to say I'm using this number based on the 2014 value that was put on that interest, and the 2014 value was approximately $16 million. So in addition to the 12, if I got those rights, if the court approved it, and we were able to pursue those, the pursuit of that somewhere in the vicinity of $16 million. Of course, it could be more today, it could be less today, and that's not the only right and interest that I get. That's just one of many. So the potential for this settlement to be well into the 20s, including the $12 million that we're getting, is very, very real. That is now in front of the federal court. The federal judge has said that he is likely not going to address that settlement until the motions to dismiss the federal litigation are actually heard, which makes very logical sense, because if there is a defendant that would otherwise object to the settlement, if they're out of the case, then they really don't have any axe to grind with it. So it makes sense to have the judge say, let's get through the motions to dismiss first, and then we'll proceed with the settlement piece. Although in one of the phone conferences, he did indicate that he was expecting that to come before him sometime in March, maybe April. So we're talking another 4 months before that gets in front of the federal court. In addition to that, you probably have seen I entered into a potential settlement with Charter Care Foundation, and this is a settlement which involves the approximate $8.5 million of charitable assets that were transferred to the Rhode Island Foundation at the time that the conversion application was approved. Just to give you a little summary on that, when a hospital goes through a conversion from a not-for-profit to a for-profit, the for-profit is not able to handle the charitable assets that the not-for-profit was holding. So what has to happen is that through a process with the Attorney General, there has to be an orderly move of those funds to an agency, in this case the Rhode Island Foundation, that can distribute those funds in accordance with the donor's intent or as close to the donor's intent as possible. We had alleged and asserted that under certain statutes in the state of Rhode Island, that those funds, even though they were charitable assets, should have been used to fund the plan because the plan was a debt of the entity before they went to be used for those charitable purposes. And part of our argument is that you, as pension holders, had no idea what was happening because you didn't know the problem with your pension plan. You didn't know that there was a problem with it, so you didn't know that you could have or maybe had the right to possibly object to that transfer. So we sought to intervene and reopen that matter to try to claw those funds back. In the course of that litigation or that battle, that was why the Charter Care Foundation was added as a defendant, and the Rhode Island Foundation for that matter. We've now entered into a settlement which would bring another $4.5 million into the estate. So of that approximate $8 to $9 million, I don't know what the value of it is today, we've settled out at $4.5 million. The reason why we settled it is just like any settlement, there's risks associated with litigation. There's time and expense associated with litigation. And when we weighed out the expense that it would cost to pursue, as well as the potential risk to be victorious in that pursuit, I felt that a $4.5 million settlement was a reasonable settlement in this case. Just to give you a little context of it, the Attorney General has, in one of their pleadings, I can't remember which one, but they put a footnote in saying that they believed that there was an argument that approximately 3.8 million of those funds might not have been specific grants that could have been consumed into the general fund. So they were at least acknowledging on some level that there was a portion of the 8.5 that arguably maybe was classified improperly and could have been used to fund things like the plan. That is going before the judge on Friday. Judge Stern, have we received any objections on that? I don't believe we have. No. So as of right now, we have not received any objections. Obviously, we're not going to receive an objection from Charter Care Foundation because we're settling with them. There is an interplay. The reason why the settlement took so long to come together is because the settlement with St. Joe's Roger Williamson Charter Care Community Board had aspects that impact the Charter Care Foundation. As you might recall, Charter Care Foundation objected. They were probably one of the most vocal objectors to that settlement. So we actually had to find a way to mesh those two settlements together so that certain things that were dealt with in what I'm going to call Settlement 1 are also consistently dealt with in Settlement 2. We believe that we found that mesh, and that's what we presented to the court. In absent objection, we expect Judge Stern to approve that as well. Actually, even with an objection, I expect Judge Stern to approve that settlement as well. And again, same process. We will settle with the Charter Care Foundation, assuming Judge Stern approves it. That will move us to the federal court because then the federal court judge will have to approve that. Hopefully, because of the timing on all of this, with the judge saying that he's going to defer decisions on Settlement 1 until after the motions to dismiss, it's likely that we're going to be able to deal with both of these settlements at once. And so that would, assuming approval by the federal court, that would give us about $16.5 million into the plan sometime in the April, May, June range, although do not hold me to those dates because the court system can back it up. We also have a general report scheduled for Friday, the thing that I think is most important to each of you, other than kind of a general understanding of what's going on, is that still at this time I am not making any recommendation to the court to adjust benefits in any way, either applications, elections, or current receipt of benefits. And I'm asking the court, as I have in the past, to allow me to defer that for at least another 60 days towards the next report, which will happen sometime in February. So there should be no change in your benefits. I do want to address, before I take any questions, just the conditions of the market, because we have had, and if any of you read the report that's been put up on the website, I do describe it a little bit in there. We've had some, what I'll call, significant erosion in the plan in the past, I'd say 6 months, mostly beginning around March, April. And that timing and the erosion for that timing is not coincidental. I believe that it's actually linked clearly to two things in particular. One, as you all know, if you've been watching the market at all, the market is much more volatile today than it was in prior years, where we had some strong, consistent performance of the assets and the investments. The market's been a little bit more volatile, and the investment income has not been as strong. In anticipation of that, some of you might recall that in February and March of this past year, all of this year, I sat down with the investment advisor and made the decision to adjust the investment allocation. We made it slightly more conservative. Without getting into details, we were at a 60-30 split or a 65-35 split, and we are now at almost a 50-50 split. Turns out, sometimes it's better be lucky than good, that making that switch actually has insulated the plan a little bit, because the volatility has not affected the plan as much as it could have under the other allocation. Does not mean that the plan is absolutely protected from the volatility, but it's more protected than it was under the prior allocation. That said, when we started down this journey together in August of 2017, wow, that's a long time ago, August of 2017, we had approximately $86 million in the plan. Today, we have approximately $76 million in the plan. In addition to the volatility of the market, the reason why the plan started to erode more quickly in March and April is because that timing coincides with the court giving me the authority to allow applications to be reprocessed, those that had been held. And that resulted in two things. One, it resulted in retroactive payments for those of you who had been waiting since August, September to get your money. And in addition, it increased the monthly payment obligation of the plan to you as benefit holders. So we were paying out, just to give you some round numbers, we were paying out approximately $850,000 a month to cover benefits under the plan. And as of April, May, June, that number has increased to about $975,000, just below $1 million. So it's an extra $125,000, $150,000 a month that we're paying out. Obviously, that coupled with the slowdown in investments means that the plan is eroding a little bit more quickly than it had been, which is why I put in the report that approving these settlements and getting these things done as quickly as possible to get, for example, $16.5 million back into this plan would put us approximately $6 million better than we were August of 2017 as compared to $10 million less than we were in 2017. With that, I am happy to answer any questions for anybody on any topic, and I'll answer as honestly as I can. Yes?
I'm just wondering, are there any other defendants or whatever you want to call them coming forward and talking to you about settling?
I can't speak in great detail about that, but what I can tell you is that I have had what I will call 100,000-foot discussions with some of the other defendants, but nothing that I would consider real settlement discussions at this point. To be quite honest with you, I'm not completely surprised about that. With the motions to dismiss pending in federal court, getting a motion to dismiss granted gets you out, and then settling would be a waste of time and a waste of your money. Losing a motion to dismiss takes a little wind out of the sails and makes a defendant sit back and think a little bit more as to whether or not they want to go down the road of the fight. So while I was encouraged by the settlements with CCF, as well as the old St. Joe's, Roger Williams, and CCB entities, I'm not that surprised that the prospect entities and the diocesan entities have not engaged me in any real discussions. Yes?
What about ERISA? What's the status of that?
In terms of,
Are they going to cover us?
as of right now, the Pension Benefit Guarantee Corporation, which would be the federal insurer that would cover a plan, their position has not changed. And their position, as I think I've told you in the past, is it's been treated like a church plan. We don't see any reason why it should not have been treated like a church plan. And until somebody tells us differently, it's a church plan and it's not covered by us. That is something, obviously, we've alleged in the complaints both in federal and state court, that we believe that the designation of the plan as a church plan was improper, incorrect, and that we set timelines for it being improper beginning as far back as the late 90s, early 2000s, and then make a case stronger each year for why it shouldn't have been a church plan at any point thereafter. But until that's one of the main things that the federal court will be wrestling with, those are the issues that are in the federal court. Those are the ones that are the difference between the state complaint and the federal complaint, are those ERISA, PBGC-related claims. So it's unlikely that the PBGC will do anything unless either the IRS or the Department of Labor, the U.S. Department of Labor, not state, indicate that we are correct, that it was not properly a church plan, or the federal judge issues a ruling saying that it was not properly a church plan. So as of right now, we provide them with notice of every pleading. We email everything. I don't want there to be any situation where any state, any federal agency, we send it to the PBGC, the Department of Labor, and the IRS. I don't want any of them coming back to me 6 months, a year from now saying, oh, we didn't know what was going on there, and so therefore we're not responsible for it. So their counsel gets a copy directly from us via email, as well as directions that they can go to the website and so on and so forth, so that there's no surprises for them in terms of our position. Sure.
They decided that it should not have been a church plan. Would they go back and inspect the church, or was that covering to pay taxes on all that money?
That's a good question. I'm not exactly sure how the PBGC is an insurer. So the PBGC itself would be having to cover the losses for the plan up to whatever level they would cover them, depending on how it all kind of washes out. And then there is a question as to whether or not ERISA would require a payment of certain monies. To be completely honest with you, I've had those discussions, and it's more of, and I'm putting this in very simple terms right now because it's very complicated, and we'd be here probably until tomorrow if I had to explain everything, and I probably would screw 70% of it up. But the long and the short of it is that if the PBGC, for example, came in, let's just use a round number, that this plan needs $200 million to survive, and right now we have 75. And the PBGC came in and said, we're going to cover it, but you have to pay us all of the premiums that you should have paid us over the past 10 years and all these taxes, and that amounts to $30 million. I'd say, okay, here's 75, take $30 million from it. Now there's 45. you've got to protect it up to 200. So whether you're paying in 150 to get it to 200, or you're paying in 125 to get it to 200, it doesn't really matter to me. I'll pay you now, and then you can just give that money back, or however you want to deal with it. So as long as far as I'm concerned, from whether or not the church or Prospect or any of those defendants would have to pay any of those obligations, it would appear to me that as long as there are funds in the plan sufficient to do that, if the decision were PBGC must cover this plan, then paying those monies to them and reducing the number of assets in the plan, meaning they have to insure more, they have to cover more, it really wouldn't matter to me. And I think that's probably what the diocese or Prospect or whoever was found to be responsible, if anybody, would probably argue, is the assets are right there, you can take them from there.
Remember that there's a total of about 14 entities that we're going to go after. Is it a certain dollar amount that you're aiming for overall, or would there be a point where you reach enough, that, best case scenario, you reach enough with, let's say, 6 of them, would you still go after the whole number of people?
Yeah, I'm going after everybody. I do have a number, which is whatever the actuary tells me is necessary to pay everybody in this room out 100% for the rest of their lives as they expected their pension to do. Realistically, I don't think settlement and litigation will get us there, but I'm hopeful that it will. But as I'm going through each settlement, it's not as if the number, let's say, for the diocese, it's like, okay, well, let's say the settlement with St. Joe's, Roger Williams, and CCB ends up being $30 million. And then we got 4.5, where I can go to the diocese and say, okay, lucky you. The other party settled, so we're $35 million into it. So I'm not going to hold you responsible for everything that I think you should be responsible for. I'm going to discount that for you. I'm going to go after them for it because we've got expenses. So whatever we're going to be paying, whatever they are going to be paying us if there's a settlement, or whatever they're going to be paying us if there is a judgment in our favor, there's cost and expense associated with that, and that's under consideration as well. Okay.
Have you heard from the actuary the amount we need?
Have I heard from the actuary the amount that we need? Not yet. What one thing I could have said to you in my opening remarks, and I didn't, and so I'll say it now, is the team I put together, which is the new actuary is GRS. We have an accounting firm by the name of Caliber. Mercer is still the investment advisor. And then I've hired a couple of experts down in Washington, D.C. with regard to ERISA and IRS issues. Caliber is right now doing an audit for the plan, and GRS is doing the plan valuation for the 2017 plan year, so the plan year that ended as of June 30th of this past year. I was under the impression that Angel was doing it. We found out that Angel actually not only didn't they do it, they hadn't even started it yet. So GRS is putting that together. Once that is together along with the audit, we will know exactly what the problem is with the plan based on current conditions and current numbers. And I will share that with everybody in the court once I have that information. We are probably maybe about a month or so. I don't want to commit them to a date, but I think we're about a month or so away, possibly mid-January, from having all of those completed. One of the bigger problems is GRS took a longer period of time to get them all of the information that Angel had. We expected it to be done sometime around September. I think I've still been receiving emails that they're still making those. Yeah, they're still making transfers because apparently all of the documents, Aon was the actuary before Angel, And according to what Angel has told us is when they came on board, Aon gave them all paper copies, and they never turned those into digital. So there are boxes and boxes and boxes of paper copies that had to be scanned in and sent over digitally, as well as the hard copies as well. And then they had to be gone through and organized and made sure that everything was there. So what was originally anticipated to be a 30 to 45-day transition has now turned into somewhere around 120-day transition. So that put them behind the 8 ball a little bit in terms of what my goal was in terms of priorities, which is making sure that GRS is responding to each of your inquiries, that they're processing applications and elections in a timely way, and we can get to that other information as we need to. But I wanted to make sure that they were responding to and getting the work done for the participants first before they started doing the things that I need them to do. Does that answer your question? Okay. Any other questions?
How come the court dates have been flipping around?
Well, the month of December is an interesting and difficult month. The part of the reason why they've been flipping around is because the attorneys have been tweaking and revamping things. But the last change, my understanding, the last change was because the court's vacation schedule and the judge's assignment during the vacation schedule came out, and he needed to move things along. So I think it was originally supposed to be the 18th. The 18th, which is in the court vacation schedule. I think they go on vacation the day before that or something like that. And Judge Stern is only going to, I think he's there on the 24th, Christmas Eve. And so as opposed, instead of getting all of us in court on Christmas Eve to listen to all of this, he moved it to Friday. So that's why we've done it. That happens a lot in, so what? And then we consolidated everything rather than saying, okay, well, let's put something down for Tuesday and then Thursday and then Friday. We just moved everything into one date. That happens a lot between Thanksgiving and Christmas because of the court break. Hopefully you'll see a lot less of that. I can't promise you that you won't see it again, but we'll see a lot less of it.
Did Prospect respond to the contempt of court hearing with the monitoring reports?
So did Prospect respond to what?
Contempt of court hearing with the monitoring reports to the Attorney General, and they also pulled back their request to the Department of Health and Attorney General.
I'll answer the second question first. They did pull back their request to the Attorney General and the Department of Health. So the question was, did Prospect, we went in on 2 motions to adjudge them in contempt. One was because they initiated proceedings in front of the Attorney General and the Department of Health, which we believed was a way to go around the judge and get a decision to preclude the settlement, or at least portions of the settlement. And then the second motion to adjudge them in contempt was for failure to provide certain information related to their funding obligations post-conversion. With regard to the first contempt, which was the Attorney General and Department of Health, they did withdraw their pleading or their requests or their actions in front of those 2 agencies. And I guess although the judge is still holding his decision on what he'll do as a result of them doing it in the first place, he at least has been satisfied that they have withdrawn those. With regard to the funding piece, that's a little more complicated. And there's been, and I can't get into it right now because, to be completely honest with you, it kind of caught me off guard and I was completely confused. And I'm still a little confused as to what's going on. But apparently there was, at some point in time, the Attorney General's office granted to Prospect an extension for that funding. Nobody ever said anything about it. Nobody ever advised us about it. The way we found out about it was we were going back through the documents, the million documents that had been produced, and there was a letter that was kind of in that pile, literally one or two letters back and forth, where there was a request for an extension. The reason why I say that I'm confused about it was, one, nobody told us. If you're asking, did you fund as the conversion required, you would have thought that either the Attorney General or Prospect would have said, well, no, we didn't, but we didn't have to because they gave us an extension, or we gave them an extension, whatever the case, and that never came out. The other thing is that the impact on that extension it's unclear as to what that does to that 15%, 20%, 27% interest that Roger Williams, St. Joe's, and Charter Care Community Board, in this instance it's Charter Care Community Board, has in the Prospect entity, because we have an option that we have to exercise, or that CCCB needs to exercise in June of 19. But if the funding hasn't been done, then it's impossible to figure out what the value of that option is and whether or not it's prudent to actually exercise it. And we've spoken to CCCB, and they were completely unaware that Prospect asked for the extension or that the Attorney General granted the extension. So we're trying to work through that right now. That's kind of a very 50,000-foot understanding of what's going on with that. The judge is aware of it. He was just as surprised as I was when I found out about it, and we're trying to deal with that and what to do with that. Any other questions? I will say things like that are probably some of the more frustrating, because you ask a question and you would expect, it's possible that a party might forget, but two parties to forget, especially when they were the ones that communicated with each other about it, it just seems a little odd. Don't hold me on this date, but I believe that the request was made in 2016. It could have been as early as 2015. It was after the conversion was approved, after the conditions had been set by the Attorney General, and well before the commencement of this case. So somewhere in the 15-16 time frame. And the odd thing was it was letter correspondence back and forth. We'd like the extension with some reasons, and a letter going back saying, sure, you can have 2 years. So.
A letter is fishy in this electronic stage.
Well, might have been emails.
Yeah.
But it's. It is frustrating. It was something that we were not expecting. Obviously, we thought that there was funding that at least was supposed to have been done, and on some level we were hoping was done. And then we find out that not only hasn't there been any funding, but that the reason is because a public hearing and conversion, which set certain conditions, including the funding, was amended post-conversion without notice to anybody. So it's problematic, but we're gonna deal with it. I can't speak to it. I'm a civil lawyer. I can't speak to whether it's criminal. It's this will have to be something that we discuss with the judge, and then most likely something that we discuss with the Attorney General's office, meaning the new Attorney General coming in, because quite frankly, I'm not even going to pretend to tell you that I know all the protocol that would be appropriate or inappropriate for that office in terms of post-conversion approvals or requests or things like that. So at this point in time, we just recently found out, when I say recently, I mean within the past 2 to 3 weeks, and we're trying to get our head around the impact on the option, which is in June. while at the same time trying to figure out how it happened the way it did and why. And if something went wrong, I can promise you that we will bring it to the court's attention, as we have brought everything to the court's attention that we think has gone wrong. And if we determine that it was done properly, then we'll let everybody know that too. And if it's gray, we'll tell the court why we think practically it was the wrong thing to do. Any other questions? Yes?
When the companies have a motion for dismissal, is it the judge that makes a decision, or is it something you see and you argue against?
Well, it's the question is on the motions to dismiss, is it something that the judge rules on, or is it something that I argue against? The answer to that is yes to both. So the motions to dismiss are filed. I get a chance to respond to those. Then they get a chance to respond to my response. Then ultimately we have a hearing in front of the federal judge in which the parties argue their positions on my case, why the motions to dismiss should be denied, and on theirs, why the motions to dismiss should be granted. It is possible, there are a couple of scenarios that could go on. A judge could grant a motion to dismiss, a judge could deny a motion to dismiss, or a judge could partially grant the motion to dismiss to some counts and not to all counts, and to some defendants but not to all defendants. So it's a typical process in litigation is to have these motions filed, but it'll be for the judge ultimately to decide based on the law. Now the benefit is on a motion to dismiss, because you haven't really gone through trial yet. So there's a very difficult way to know whether or not what we've said in our complaint is actually true. There hasn't been any evidence, no depositions, nothing like that. So the rules are on a motion to dismiss that the assertions made in the complaint are all believed to be 100% true. And even if they are believed to be 100% true and accurate, there's still a reason why the court should dismiss them, because they don't provide a basis for relief, or it's not actionable or something like that. It's difficult to get over a motion to dismiss hurdle because of that, because the complaint is taken 100% as factually accurate. But it does happen. It's not impossible for motions to dismiss to grant. But Judge Smith will wrestle with all of those, and I've got a lot of faith in that court and him and his ability, and I know he'll make the right decision, whatever that decision is. Anything else? Yes?
We can expect that check for the next 2 months, basically.
At the very least. At the very least. When I say, and I think I've said this before, you will not get like 10 days notice of a change that's going to be made. It's going to be something where, quite frankly, unless it is an absolute emergency, the bottom falls out of the market or something, you will have very significant advance notice of anything that I'm proposing to do. And then there will be the ability for everybody and anybody to either agree with me or to say that I shouldn't be able to do what I'm trying to do. So when I say that I've asked the court I've told the court that I'm not ready to make a change now, and I'd like to defer that for 2 months, it's unlikely that in 2 months you're going to see me come forward with a plan. It would be, if anything, in 2 months I'd be letting the judge know that I've got some serious concerns and I think that changes do need to be made, and that I'm going to work between now and the next report to actually get those changes in a way that I think that the court should consider and adopt. So at the very least, you're looking at 60 days. But more likely 120 or longer. And I'm telling you, and I've said this at other meetings, as I stand here today, I have not considered cutting benefits. So I'm not, there's nothing that I'm working on when I leave here in my office to say, okay, what do we have to do? Actually, the members of the advisory committee who have been assembled for that purpose can tell you that with the change of the actuary, we haven't met, and I wouldn't be recommending a change like that without meeting with them at least a few times to get their opinion on what I'm suggesting. So you can rest assured that you'll be getting your check well into 2019 without any change, or even without the discussion of a change. Again, absent an emergent circumstance which I can't prevent and which I need to do something to try to protect the plan as a whole. Hopefully the money on the settlement will come in before that happens, so whatever emergency happens will get offset by the infusion of cash from those settlements.
Speaking of checks,
Yes.
I had an incident this December. I didn't get my check. I have an actual physical check sent to me because I was mad at St. Joe's when I left there and made them mail it. But anyway, that's neither here nor there. For the first time in I don't even know how many years I've been collecting, I did not get the check the 2 to 3 days before the first of the month.
Okay.
Always get it, like the 28th, 27th, whatever. I called Julie on the 3rd and said, I haven't gotten my check. I don't know where it is. I then called the pension company, and they convinced me to wait a couple of days to see if the mail was mixed up or whatever. Long story short, we ended up with Thanksgiving mail was a problem, and then we ended up with a federal holiday on Wednesday, so we didn't get any mail. I didn't get the check until 7:30 Thursday night. I got the mail. And it was dated December 3rd. That's never happened before. It's always been dated the 1st.
All right.
And I was talking to Julie about it before the meeting, and she said maybe it was like the 1st was a Saturday. It could have something to do with that.
It could have. It's Bank of America who cuts the checks.
They were useless, right?
Okay.
They connected me to the Bank of America pension company.
Okay.
Which is really helpful.
The reason I say that is because Bank of America has been the one who's been cutting the checks on the benefits long before I came into play. And we have done nothing. The actuary doesn't have anything to do with that. It's the investment manager making sure that investments are liquidated enough to fund the account. That could have been, I'll look into it. Have you looked into it yet? Okay. So I'll look into it because it may have been just kind of a perfect storm of problems between holidays and dates and liquidation of assets, because it takes a few days to take an investment, turn it into cash, and then put it in. Hopefully that was the anomaly, the exception.
Now I need some help with my checking account.
Give Julie a call. She's very good at that. I will tell. I don't even touch the checking accounts at the office. I won't let her give me passwords to any of those accounts. She does it all.
That might have been a check problem. Ours is direct deposit, and it was there on the first.
Yeah.
And it was there on the 1st?
Yeah.
Okay.
The direct deposits were,
The
but I'm wondering if anyone else who got a paper check.
I get direct deposit, and mine told me direct deposit, your first goes on a Saturday or Sunday. It's not dated
Until the following Monday? Okay. That may have been the problem. September, October. All right. So Julie tells me that this is the first time since we've made all these changes with GRS and everything else that the first landed on a weekend. So it could have just been the coincidence of all of that.
GRS was wonderful. They were very helpful.
I'm glad to hear that. They will not deal with them.
Right.
Yeah. So Julie just told me that it's probably a better idea to either contact us or GRS as opposed to Bank of America, because Bank of America won't deal with any of you guys individually, because they're managing the plan, so they would be contacting me anyhow. So if you do have a problem like that, if it's related to your application or your election, obviously call up GRS first. And if you don't get your check, let us know, and we'll track down why that happened and get your check issued if it hasn't been.
That might be the answer, I'm not sure. I have a friend who gets her pension, and she's moved out of state, and she doesn't want it deposited to the Rhode Island bank anymore because she can't access it from the state that she lives in now. But I'm not sure who she spoke with, but she was told that she can't change anything about where her pension goes, what bank her pension goes to.
No, she should be able to do that. If she calls GRS, because what they will do is, and I'll ask Julie to correct me when I give wrong information right now, GRS will take that information on the change of the bank account, and they will send it to us, and I'll review it and sign it, send it back to approve that change. Because if you're at...
I have deposited in a Bank of America account, but I want to close that account. So if I want to have it go into Citizens, I can do that.
That's right. If you decide that you're going to change banking institutions, you shouldn't be precluded from doing that because of your pension check. Any other questions? Yes.
What is GRS?
They are the new actuary.
I know, what's the real name?
Oh, Gabriel, Roeder, and Smith. Is that correct? Gabriel, Roeder, and R-O-D-E-R, Roeder. R-O-E-D-E-R? Oh, R-O-E-D-E-R. I should just have her up here. Any other questions? If there are none, I want to wish everybody a Merry, Merry Christmas, happy and safe New Year. I will see you all, other than court, I will see you next year. And again, if you have any questions, let us know. I appreciate all your patience.